In the second hour of today's broadcast, I want to turn over our studies to return to law, if we will. And we're going to look into the trust. You know, who has the trust anyway? Do they have your trust? Do they have mine? Not really. Not much trust. Don't trust them very much. We can find a little bit out of the encyclopedias to get started, and there's lots of stuff on my table here. We'll just go wherever we want. So we're going to talk about trusts for a little while. Trust is a right of property, real or personal, held by one party for the benefit of another. Who's holding your property these days? You know, you got to pay your property taxes, your personal property taxes, register your vehicle. You know, get a license plate on the back of it, regular inspection stickers, has to go through and pass the emissions and all of that. You got to keep it insured. If they pull you over alongside the road, they can just haul you out, take you away, impound your car, and sell it. You'll never see it again. It's a right of property, real or personal, held by one party for the benefit of another. You know, the Queen of England owned all the property in North America. The Rothschilds, the Pope of Rome, the King of Siam. The party holding is called the trustee. Look at the Declaration of Independence and follow through the Articles of Confederation and then off into the Constitution. Is the Constitution a trust agreement? Are they the trustees, we the people? Were they trying to build a trust here? The party for whose benefit the right is held is called the sesquity trust, or the beneficiary. I'll get that word right one of these days. It's law French, basically. The sesquity trust, or the beneficiary. So we're the beneficiaries of this whole big deal if we can claim it. We can prove there was a trust that was established here. It was set up, you know. The right of property, real or personal, held by one party for the benefit of another. Wow, interesting stuff. The party establishing the trust is variously called the donor, the creator, the settler, the trustor, or the founder. We talk about our founding fathers, right? The Declaration, you know, we hold these truths to be self-evident that all men are created. That's the capital C stuff there. By our creator, it's a trust. Weren't we called settlers? They do that in Israel, too. They're called settlers, right? They're settling Gaza. They're settling Palestine. Really pissing off the Palestinians in the process. Trustor. In God we trust. Wow. Sometimes the equitable title of the beneficiary, sometimes the obligations of the trustee, and sometimes the right held is called the trust. Different ways of looking at it. But the right of a beneficiary is in the trust. All right. The obligation of the trustee results from the trust, and the right held is the subject matter of the trust. Now, this is out of an encyclopedia, the Universal World Reference Encyclopedia, rather old piece of relatively common material, copyrighted back in 1955. Originally copyrighted in 1942. Hard to say when this article was written. But the right of a beneficiary is in the trust. The obligation of the trustee results from the trust, and the right held is the subject matter of the trust. What rights do you have in this trust? In God we trust. The United Nations, the United States, the state of Missouri. So sometime back, two of our listeners sent to me a wonderful DVD program. It runs an hour and 20 minutes. It's part one of a series called The Legacy. You can find their website at www.the-legacy.info. www.the-legacy.info. Right? Rather interesting DVD. Really talks about trusts. Opened my eyes a little bit to the concept. All right, and that's what we're looking at today, right out of the encyclopedia a little bit, and then we're going to go to other sources. But again, altogether, they constitute the trust. In a more technical sense, a trust is the right, enforceable solely in a court of equity. Right? The 3 E's of sustainable development: economy, environment, and equity. A trust. Enforceable solely in a court of equity. to the beneficial enjoyment of property of which the legal title is in another. No particular or technical words are required to create a trust. It is sufficient if it clearly appears that there was an intention to create a trust or to confer a benefit best carried out by means thereof. That's the opening paragraph in this encyclopedia article. Quite revealing if you apply that opening article or opening paragraph to the constitutions. You might see that there's a bit of a trust relationship that's been built. There's a suggestion of the trust, as the term is used today in the Roman, and I'll just go fidei commissiem, although it cannot correctly be said that the entire equity jurisprudence of trust was derived from the Roman law. You can go back and look at Blackstone's commentaries, which we won't do today, and Sir Edward Coke, and you can find more there as well. Trusts were probably first introduced into the English law to evade the statutes of mortmain, from which some people believe that we get mortgages, which prohibited lands from being granted to religious institutions, and the statute of uses, which combined the legal and equitable title. Legal title and equitable title. Rights of possession, the rights of property and legal title. Some of the things that go in there, I guess. Continuing, trusts were probably first introduced into the English law again to evade the statutes of mortmain. Continues, trusts are divided with regards to the manner of their creation into two classes, express and implied. Express, that's written, or implied, just by looking at the information. Express trusts are those which are created by the direct and positive acts of the parties, by some writing, or by some word of mouth. Express trusts are usually found in preliminary sealed instruments such as marriage articles or articles for the purchase of land, in formal conveyances such as marriage settlements, terms for years, mortgages or assignments for the payment of debt, and in wills and testaments when the requests involve fiduciary interest for private benefit or public charity. Now this is pretty interesting writing to me for a couple of reasons. One, because it's written quite simply, without all the legalese that we'll find in other places. But it's also very revealing when you think about how huge this concept of trust is and how much of our lives may be embraced within either an express or an implied trust. The distinction between a private and a public or charitable trust is that the former is created and intended for the convenience and the support of private individuals or families, while the latter is created and intended for the general public good, the greatest good of the greatest number, right? The rules governing the two classes differ widely. It is more favorably upon gifts to charities and will endeavor to carry them into effect if it can be done consistently with even the broadest interpretation of the rules of law, whereas in the case of a private trust, the courts may apply a more rigid interpretation. For example, uncertainty is permitted in describing the objects, purposes, and beneficiaries in the case of charitable trusts. Don't have to worry about cribbing up the notes too much. We've got free access to the archives here. You can go back and listen to this. Ponder on it a little bit. Maybe do some digging in your own work. But remember yesterday when we were talking about this trivium and quadrivium. We start out with the grammar in the trivium, and from that we move into the dialectic, all right, logic. And then from that we move into rhetoric. And this could be understood as oratory, or bringing it all together. And unfortunately, in the 1950s, this particular set of encyclopedias was really written for an intermediate audience. This set of encyclopedias were commonly just sold to householders for the benefit of the family, the husband, the wife, and the young ones going to school. Probably weren't terribly expensive. They weren't. I actually have when I got this set of encyclopedias donated to our library, it actually comes with the contract to purchase. Well, it's not very expensive, but in those days the dollar went far further. But to me it's interesting because we're looking at this idea of the trivium and the quadrivium, and we realize that so long ago, even in Rome, that a young person would shadow their father around, a young boy would follow his dad around, and he would listen as Dad dealt with the various creditors in his office in the morning, and then they would go out and about through the course of the day, engaging in local politics, etc. Interesting. But trusts are not always our friends. There have been antitrust parties, anti-monopoly parties, trust busters, etc. Busting the trusts. We'll set away the encyclopedia for a moment. Go to America Past and Present. This by Divine Breen, Fredrickson and Williams. This is a very interesting book which would be suitable for perhaps an advanced study in American history. And I'm not saying that everything that you find in these books is spot on, but it gives you a pretty good understanding of where things were going in education. This was written by Robert A. Divine, the University of Texas, T.H. Breen, Northwestern University, George Fredrickson, the Northwestern University, and R. Hal Williams, Southern Methodist University. It's a Scott Forsman and Company publication, copyright 1984. Busting the Trust, page 668. There's a widespread conviction in the minds of the American people that the great corporations known as trusts are in certain of their features and tendencies hurtful to the general welfare. And of course we saw the emergence of the trust when we were studying out of Gustavus Myers, the history of the great American fortunes, and damn right, that's straight up. That's what we found. The creation of these trusts had a tendency to be hurtful to the general welfare. We'll be right back.